Thank you, Your Honor. Good morning. My name is Jennifer Fury. I represent Taylor Janelle Anderson, the appellant in this matter. I'd like to reserve 4 minutes, if that's okay. And I apologize, I'm losing my voice. I'll try and do the best that I can. There were 3 issues on appeal. There was a failure of the court to grant the bill of particulars, which has an abuse of discretion standard, and then the failure of the court to grant the judgment of acquittal on the issues of the traveling and solicitation and the material harmful to a minor. And that is de novo review. I'll start with, just go right into the issues unless the court has some confusion or question about the facts of the case as they were laid out. I'll start directly with the issues with the bill of particulars. This case was set for trial the week before Christmas of 2022. The defendant had been arrested in September of 2021. On November 30th, 2022, after the case had been pending for over a year and all depositions had been taken under the amended information, the first amended information, which changed charges, not dates, the state then changed and expanded the dates of the possibility of what the criminal activity was for counts 1 and 2 of the information, that being the unlawful sexual conduct and the traveling. Ultimately, it doesn't present a problem for the appellant on counts 1 and 2 as to the sex conduct and the traveling, because the jury did not convict her of those. And despite that the dates expanded on those were covered acts in the deposition, as far as there was 1 act that was alleged, there was 1 traveling that was alleged, and although an exact date was not given, those acts were fairly obvious from depositions.
The second information is pretty thorough, isn't it? How did it show? How did it seem to be inadequate?
Well, there was a second amended information, and the second amended information.
There's a time frame between May 27, 2021 and August 20, 2021.
Correct. As it related to the solicitation part of the traveling, that is what constituted the solicitation. Original date was August 20th, and all depositions were conducted August 20th of 2021. And all depositions were conducted, especially of the alleged victim, focusing on what was the alleged solicitation that occurred on or about August 20th, 2021. They were well covered what it was that preceded the date of the alleged traveling that could have been considered solicitation. Once the dates opened up, and now it became a situation where it was, what are we talking about is the solicitation? What are we calling the acts or intended acts that were meant to solicit the traveling and the sexual conduct? If you had a date certain, he had been deposed on that, and the questions about what was said or what wasn't said was covered. But when you opened it up to all sorts of activity that there was no testimony about, and ultimately at trial, there was no testimony about. There were barefaced general conclusory statements, but there were no actual facts or discussions or anything else like that. So
well, let me ask you this. Was there any attempt to, when the amended information was made, was there any attempt to reopen discovery to then go develop additional facts? Because I think that's what I'm hearing you say. Wouldn't we have to find prejudice or?
Correct. And to that end, it's not that those issues were not covered in deposition. They were. The questions had been asked, and they were asked at trial. What was said? What was done at any point?
Okay, so then I'm having difficulty finding how the amendment with a range of dates was prejudicial to the defendant here, because before there were specific acts that were alleged, right? And then I think there, from what I'm seeing from the testimony, there was difficulty with narrowing down when the actual videos were taken. So it was appropriate then to have a range of dates as opposed to specific dates because they were uncertain of when those specific dates were.
It appeared that way at first, and I think the state actually argued that at the motion for bill of particulars, that the dates were not known. And there was some confusion, and I think there was confusion on the state's part and confusion on the judge's part. There were two types of videos in this case. There were the videos of the mutual masturbation, and then there was a video that was taken by the victim of the defendant in the front seat while he was sitting in the back seat of the vehicle. The video from the back seat of the vehicle had been deleted by the victim. And because he had deleted it, the testimony that had been gathered at deposition and that was ultimately produced at trial was that the August 20th date, and that was the date that originally began, was of the video from the back seat. That was the only one that had a date that was uncertain because the Detective Luke testified both in deposition and in trial. I don't know what that date is. I'm pulling it off of his cache out of his cell phone, and that could be the date that it was deleted. It could be the date that it was saved. It could be any number of dates. The dates for the two videos, 4 or 5 videos, whatever they were, that were the mutual masturbation videos, those were dates that we knew. We knew that those occurred on 7/24 and that those occurred on 8/25, I believe, were the two dates. So those were dates certain. And I was not, as we stated in the bill of particulars, I was fine with the state changing it from the solicitation are these two videos, and they are on 7/24 and 8/25. That would have been fine. That makes sense to me. And in effect, the state had said, this is what we intend on relying upon. So it was confusing to the defense that upon saying this is what we're going to do, why do we need the entire summer to talk about these two videos when they...
Let me follow up on Judge Smith's question because I'm not sure that I heard the answer.
Okay.
How was your client prejudiced in preparation for trial or defending at trial?
Because what happened then was that we had all of these
You
other...
might have been overly prepared.
It was, well, I mean, it was the problem.
So what is the prejudice? And point to something that you couldn't anticipate that came out at trial, something that was wholly a shock to the system.
I apologize. It wasn't so much a trial preparation as it allowed for arguments of things to be criminal.
Wasn't it generally understood we're talking about these 4 videos?
Part of my problem was that I thought that is what we were talking about. And I knew from deposition and I knew what was going to come out in trial testimony that one of them came before the event in Bradenton and one came after. And so I was put in the position where as defense counsel, my argument was going to be, well, this can't be solicitation for the event that occurred before it. And all of a sudden, the week before trial, it becomes, well, wait a minute, we're not just talking about, in reality, this one video that comes before it. We're talking about a bunch of conversations that when asked at deposition.
But isn't that reasonable to, I mean, this is a solicitation, right?
Correct.
And so, there are things that lead up to a solicitation that are relevant. So wasn't that reasonable that would have opened up any prior discussions prior to those events?
It would have been had the defense been put on notice. And I think there is a difference, and it may be a difference without.
I mean, are you saying that you weren't aware of that video in the car?
Oh, no, I was.
Okay.
I was. But the situation was that the defense was put in the position of saying, if the video is solicitation, if the videos are solicitation, then that's one thing. But if we're talking about all of these other conversations are, in essence, laying context for those videos or context for other things, then they are not the crime, they are the context for the videos. But the problem was that once you changed and made them part of the actual information in criminal act, they're no longer providing just context, they're the actual crime. So, for example, if you had an actual case where I'm saying, look, you're guilty of solicitation because on August 20th, we had an actual conversation about, hey, look, I would really like to meet up with you. I want to get together and do X, Y, and Z. I want to engage in oral sex or whatever the case may be. And all of the conversations that came before that were about, hey, where do you go to school? What do you do? I like people like that. Those things might provide context for the crime, but are they the crime themselves? And that made a difference to me because the only evidence I had was that all of those conversations, there was never going to be any testimony about what they were. This witness got up on the stand at trial and during deposition and said, I don't remember what they were. I don't know what we talked about. I don't remember what we said. And other than making a general conclusory statement that they were, some of them were either sexual in nature or they were flirtatious and informative, I think were the words that he used. I don't know what that means. And so are we going to allow the state to argue that whatever those conversations are, if he believes them to be solicitation, then that can be part of the crime, even though the defense is not put on notice about what they are and how they specifically solicited the sexual act. It put us at a...
Shortly after the victim returned from Texas, right? She went and picked him up in her car.
The course of events were, he left school for the summer. He was traveling all summer long. He played baseball for IMG Academy. He was never in Manatee County for the entire summer at any point until August the 7th. The defense says August the 7th because of other information. I don't know that that was ever elicited from the witnesses that it was August the 7th, other than the defendant. The defendant knew it was August the 7th, but August the 7th, he came back into town for a baseball tournament at IMG Academy. Did not inform her he was coming before he returned. He just showed up and said, hey, I'm in town. On that date is when the video from the back of the car was taken, where she is sitting in the front seat completely clothed and he is in the back seat of the vehicle. There's nothing lewd going on. It's just supposed to be video evidence that they were together on the 7th is basically what it was entered for.
They're in her car, she picked him up, right?
Correct.
And according to him, there was talk about sexual activities during that period when she picked him up, right?
He said that under direct, but then under cross, what he sort of fixed and came back on once he got impeached about it was that it was implied, we had talked about things earlier, because what he had said in deposition was, no, we did not talk about having sex. We talked about hanging out. She was going to come pick me up. We were going to hang out. And then he then corrected himself under cross and said, well, I was talking about from before. I was talking about from the summer that we had talked about having sex, is what he basically corrected himself.
What was the purpose of these tapes being sent to him if it wasn't just to do solicit, lure, or entice?
Pardon?
What was the purpose? Why is he sending her these naked videos of him naked?
I'm not sure I understand the question. I apologize. Why was he sending or why was she sending?
Why was she sending?
She didn't send any videos. This was a live transmission of the two of them over FaceTime mutually masturbating. She didn't send him anything. They were together live at the same time, and it was snippets of it. So she didn't send him anything. They were live transmission. contemporaneously.
And that happened through FaceTime, right?
Correct.
When they weren't together.
Correct. He was in Texas and
They
she
were
was in,
engaging in separate sexual activity, but at the same time in FaceTime. And then after all of that leading up to it, she then goes to pick him up. And in her car, and then he testified they had sex in the car.
correct. The jury didn't find him or her guilty of that ultimately.
No, I understand. But as far as the solicitation, you're saying, what does any of that matter leading up to it when the video itself only shows them in the car? So I think for purposes of solicitation, you have the videos leading up to it when they weren't even, physically together.
And again, Your Honor, I apologize. I mean, again, I'll point out, only one of those incidents occurred before she showed up. So the other one was after. The video from the back of the car was not, the state wasn't saying that that was solicitation. The state put in the video from the back of the.
Well, because that probably would have been after.
Correct, it was after, as was the other mutual masturbation video. That was after. And so the issue for the bill of particulars was to find out, is it these two videos? And if that is it, that's fine. And we know dates certain for that. But once you open it up to all the dates, now we don't know what you mean by are the rest of the conversations, which there was no testimony about.
Counsel, you've used 16 of the 20 hearings before, and we understand you're not abandoning the other issues.
Okay, so have I used 16
You
and
have 4 minutes left for rebuttal.
for rebuttal? I've not abandoned the other two JOA arguments. I can address those after if that's okay.
We've read the briefs as well, so.
Pardon?
We've also read the briefs, so.
Okay, and then I understand.
understand.
I understand that.
Morning, Your Honors. May it please the court, my name is Claire. May it please the court, my name is Claire Murga. I represent the state in this case. To address initially the issue of the dates and why it got expanded so closely after the depositions were taken, that was because during the deposition, the detective actually testified that they weren't sure what the dates of the videos themselves were because of the nature of how the data was cached. That was the sole issue. And during that hearing, the state, in fact, confirmed that they were relying on the videos themselves as the evidence, specifically with specificity. There was no other specific evidence they had other than the general nature of the conversations, which defense was aware of at the time of that hearing, and which was not expanded on at trial and could not have confused the defense. The information as it was filed, the state's position is that it was sufficient to put her on notice of the charges against her, of the place, the time, the date, and that there was no prejudice to her in denying that bill of particulars, and that the trial court did not err in doing so. The other piece of information for that the state relies on is that the defense was not entitled to the exact dates if they were not known. And that was cited in my brief with Anderson as well as Jenkins. If there are any other questions about that issue, I know your honors spoke at length about it. I can answer them or I can move to issue 2. With regard to issue 2, it's the state's position that the trial court did not err in denying the judgment of acquittal as to count 2. And I believe that it was mentioned that it was only implied or that there was earlier conversations between the two that were never specified, but there is basis to find that to be sufficient for solicitation. Communication can meet the plain and ordinary meaning of seduction, solicit, lure, entice, even if the appellant does so only obliquely and only implicitly, and that was a finding in Hartley. for the fourth district in 2014. So it's just the state's position that it doesn't have to be an explicit one single conversation or text, which the state didn't even have because none of the texts were actually recovered from either of the phones due to the nature of them being deleted. But the general conversations and the general testimony from the victim that, yes, we were going to meet up to have sex. Yes, she told me we were going to have sex. And then she came and picked him up at 9 p.m. in the evening after these mutual masturbation events took place over the course of the summer, which was only from July 24th until August 7th. It's not a huge break in time there. And so with the testimony from the victim, as well as not in conflict testimony from the appellant that she did in fact travel to meet him, with the evidence presented at trial being competent and substantial or sufficient to present to the jury, the trial court did not err in denying the judgment, or the motion for judgment of acquittal on count 2. And turning to issue 3, it's the state's position again that the trial court didn't err in denying the motion for judgment of acquittal as to that count. There wasn't a factual dispute that these events took place at all. The videos were entered into evidence to capture that they captured the events that happened, the transmission of the obscenity between the two, and appellant admitted on the stand that it was her in the video. The victim testified that he engaged in these acts with appellant. The only issue was whether or not the videos themselves constituted an image. It's the state's position that they did then and they do now. And the trial court actually found in denying the judgment of acquittal that it was clear to him on a plain reading of the statute that they did in fact meet the definition of image. And so in taking that evidence in the light most favorable to the state, the trial court did not err in denying the motion for judgment of acquittal as to that count. And if there are any questions about it, I'm happy to answer them, but otherwise the state would rely on its arguments in its brief and respectfully ask this court to affirm trial court's rulings and uphold the conviction sentence of appellant. Thank you.
Your Honor, if I can address the failure to grant the JOA as to the solicitation. The issue for traveling, I don't know that it was argued at the JOA that the traveling had not been proven. However, the traveling is required to happen after a solicitation had occurred. And so the thrust of the argument at trial about the solicitation was that the one video, if that was to be what it was, occurred on July 24th. And the parties, the juvenile was in Texas, the appellant was in Florida. There was no testimony about any audio that occurred during that transmission. The juvenile did not say, while we were engaged in this, we talked about anything like, we're going to get together and do this, or I can't wait to touch you, or I can't wait for you to touch me. The only testimony that was given was that they were encouraging each other to touch themselves. And the defense's position is that encouraging the juvenile to masturbate himself on video is actually not a crime under the facts of this case. Live transmission of mutual masturbation, although she was not charged with it in the state of Florida, is not criminalized for someone over the age of 16. In fact, it's not criminalized if they would have been sitting in the same room together. So if they would have been in the same room together doing that to themselves, there is no statute which criminalizes that for a 17-year-old. Exposure requires under 800 that you be out in public. Masturbation or unlawful sexual conduct with someone over the age of 16 requires that I actually touch you. And so them sitting there via live feed doing this without any indication that they were going to be together or request to be together or request to do anything with each other, or even knowing that they were going to be together anytime soon, was not ever elicited at trial. So what you had was you had a live feed of mutual masturbation from 3 states away. And there was absolutely no evidence adduced at trial that they would be together. There was no testimony that, hey, I'm coming while that's going on. There's no testimony, hey, I'm coming in August for a tournament. You want to meet up then? That was not discussed, and there was no evidence of it. So that video being solicitation for an act of being together that was unknown is absolutely, it's a guess. It's an inference. It's a hope. It's a mere speculation. And what we did is we allowed the jury to convict her based upon that video, that it was soliciting an act in the future, maybe sometime that we would get together. The difference between this case and all of the cases that are cited by the state, Hartley, Groves, all of them, is not only is the solicitation more specific in those cases, that is a specific solicitation to violate 794, 800, 827, or some other unlawful sexual conduct. It is not a solicitation to sexual conduct.
In those cases, is there any sort of sexual activity that occurs prior? And I don't know the answer to that in those cases.
There is, the only one is I believe there is in, I don't remember whether
And I mean
it's.
usual sexual activity. I mean, I know there's pictures. in
There's
some of those
pictures,
cases,
yes,
there's
there's
pictures
no,
that
no,
are
there's
sent,
no,
But I don't recall any unusual sexual activity that proceeded.
no, there is no
But
mutual
that
sexual
makes this
activity.
case a little different.
It makes this case different, but it still doesn't get us to the point where we're talking about if it in and of itself is the sexual act. How does that, I guess what we're saying is that if we engage in any sexual act, that we are then inviting further sexual acts? Is that where we're going with this? Like if I'm engaging in a sexual act and I,
But what you're saying is as if nothing else happened after that, and then I would probably agree with you. But we're not talking about it just ended. There were additional facts that developed after the videos.
and those would be that we,
And I think that was sufficient in the light most favorable to the non-moving party, that the issue should have gone to the jury.
if the situation was that there was this mutual masturbation that occurred on 7/24, and then he travels on August 7th, what are the acts that are, or statements or whatever, that are solicitation after that point that tell us we are going?
Did you testify something to the fact that they talked about getting together and having sex? I know you said that there was some cross-examination on that issue, but.
Counsel, before you answer that, you're out of your time, but answer Judge Smith's question, and I know Judge Black had a question, so keep it short.
He said that in direct, that we talked about getting together and having sex. And when I cross-examined him, what he rolled back was, no, we did not talk about getting together and having sex when she was here. We did not. We talked about from before, it was implied that we would. And that is what he, and what he meant by that, I assume, was the videos. But when asked specifically, what were those implications? What were they? I don't know. I don't recall. What did you talk about? What did she say? I mean, this is a
Counsel,
situation.
Turn it over to Judge Black if he has his question.
Just one follow-up. What we do know is almost immediately upon him, the young man getting into town, he has this liaison. He calls her, she comes and picks him up. According to him, they have sex.
That's actually not what happens. His testimony was he came to town, he played a baseball tournament. He kept trying. The evidence was after multiple times of trying to call her, and the evidence was that he made numerous phone calls to her and she never answered him. She finally does answer him, and then when she does, yeah, they go out and go to the beach, and then they go to Culver's or something like that, I think. And so the situation is I think what I'm hearing is that if I engage in sexual activity, and in my estimation, not even unlawful sexual activity, but if I engage in sexual activity on one date while we are far apart from each other, and I make no statements or inducement to ever get together, the fact that I have engaged in this sexual activity with you in the past means that I am open to all sexual activity in the future. And I think that's dangerous.
Thank you so much. The next case on the